Chapter 7: The International Legal Environment, Playing by the Rules. Introduction to Foreign Business Transaction Law. It is important to understand that there is no uniform international commercial law. The legal systems in different countries are both disparate and complex, and it is important to comply with the laws in each country in which a multinational corporation operates. We have four inherited legal systems in the world: common law, civil or code law, Islamic law, and the commercial legal system in Marxist economies. Interpretation of each system varies by country, and the importance of law also varies. For example, one may argue that a measure of the importance is directly related to the number of attorneys per capita. Common law. It is derived from English law. It is found in England, US, Canada, and other countries that were once under English control. It is based on historical or past practices. Therefore, under common law, all judgments in court are based on precedents. Common law seeks interpretation through the past decisions of higher courts, which interpret the same statutes or apply established and customary principles of law to a similar set of facts. Code law. It is derived from Roman law. It can be found in Germany, Japan, and France, and in non-Islamic and non-Marxist countries. It is based on an all-inclusive system of written rules of law. It has three main codes: commercial, civil, and criminal. All laws are codified, but broad interpretations are possible. So now let's compare common law and code law. Common law is based on tradition, not all-inclusive, ownership of intellectual property based on use, agreements binding as long as proof of agreement is established, and acts of God interpreted as unforeseeable occurrences of nature. On the other hand, code law is based on a system of written rules, catch-all provisions with broad interpretations possible, ownership of intellectual property based on registration, agreements are not enforceable unless properly notarized or registered, acts of God interpreted as unforeseeable occurrences of nature, and human acts. For human acts, we have examples such as labor strikes or riots. Islamic law. It is based on the interpretation of the Quran. It prescribes the specific patterns of social and economic behavior for all people. Its overriding objective is social justice and equality. It prohibits investment in activities that violate the Islamic law. Islamic law and banking. Banking in Dubai requires an understanding of Islamic law and customs. Prohibition against the payment of interest and prohibition against investment in business dealing with alcohol and gambling are two of the tenets of Islamic law that affect banking. Marxist socialist tenets. The pattern for a market-driven economy differs by country. It is important to note that in these countries the law is subordinate to prevailing economic conditions, and the development of a commercial legal system has been necessary to trade with non-Marxist countries. Some formerly communist Eastern European countries had a codified legal system before the onset of communism and are adapting it to engage in global trade. Jurisdiction in international disputes. Legal disputes can arise in three situations: between governments, between a company and the government, between two companies. In the first situation, it should be resolved by the World Court at The Hague. And in situations 2 and 3, it should be handled by a court in one of the countries involved or through arbitration. Which law governs? Jurisdiction generally is determined by the jurisdiction clauses included in the contracts, or the location where a contract was entered into, or where the provisions of the contract were performed. Conciliation. It means to resolve a dispute by asking a third party to mediate. The discussion during the mediation is confidential. Therefore, it may not be used in future litigation or arbitration. It is not legally binding. Arbitration. A disinterested and informed party is chosen as a referee. This party determines the merits of the case and makes judgments both parties in conflict can honor. Many arbitral centers exist, each with standardized procedures. Arbitration clauses require agreement on the following: parties agree to rules and procedures of some arbitration tribunal. Parties agree to abide by the awards resulting from the arbitration. The results are legally binding in most countries. Litigation. It is commonly initiated by a lawsuit held in formal court. Most companies try to avoid litigation because of fear of creating poor image and damaging their public relations, because of fear of unfair treatment in foreign courts. Also, due to difficulty collecting a judgment that may otherwise have been reached in a mutually agreed settlement through arbitration, because it is expensive and requires a lot of time, and due to loss of confidentiality. Global brand names and trademarks are used to symbolize quality of a product or a company. This entices consumers to buy a good or a service. They are very important to protect, and they are among the most valuable assets of a company. Therefore, companies spend millions of dollars establishing property rights. Counterfeiting and piracy. This occurs in a range of industries. It costs companies billions of dollars in lost revenue, and in industries such as pharmaceuticals, it can cost death. Collusion between manufacturers and dishonest sellers makes counterfeiting easier. For example, a contract manufacturer that makes some extra production and sells it on his own at a lower prices. However, some feel the intellectual property regime has gone too far in favor of firms, and it hinders creativity. Inadequate protection leads to loss of legal rights in profitable markets. Patents, processes, trademarks, and copyrights. These are all valuable in all countries. However, many companies lack adequate protection against foreign exploitation. There are many cases of companies losing rights to their own trademarks and having to buy them back. Patent infringement is commonly used by competitors with no intent to compensate for use. Prior use versus registration. In common law, ownership is established by prior use. First to use is typically considered the rightful owner. In code law, ownership is established by registration. First to register is typically considered rightful owner. Use of the property does not matter. International conventions designed for mutual recognition and protection of intellectual property rights. There are three main conventions: the Paris Convention for the Protection of Industrial Property, the Inter-American Convention, and the Madrid Arrangement. Other managerial approaches. Traditional but feeble remedies in countries such as China. Prevention. Engage local representation and diligently register intellectual property with the appropriate agencies. Pursue negation and alternative dispute resolution. Complain to authorities of the host nation. Complain to domestic government and the World Trade Organization. Cyber law. Internet law is too vague. It does not address the uniqueness of the Internet. The Internet has global reach and has no political or geographic boundaries. Currently, the European Union, the US, and other countries are drafting legislation to cover the legal questions not addressed by current law. However, until complete, businesses are at risk and might have to rely on the host nation's laws. Domain names and cyber squatters. It is recommended to buy and register website names using descriptive nouns, celebrity names, and variations on company trademarks. This is important because cyber squatters register domain names to sell them at a later time for an inflated price. They hope the owner of the trademark or name will pay a huge dollar amount to acquire the URL. Traditional systems tax economic activity where it occurs. People can work from anywhere using the Internet. Therefore, when and where should these taxes be collected? And who should collect these taxes? Jurisdiction of disputes and validity of contracts. The body of cyber law is gradually being created. But for now, there are two main traveling areas: determining whose laws will prevail in legal disputes between parties located in different countries, and establishing contractual validity in electronic communications, for example, emails. Many countries are working to address these issues. Marketing laws. Countries have unique laws in marketing. In regards to promotion, development, labeling, pricing, sales, and distribution. The laws vary in strictness by country and industry, and the discrepancies create challenge for marketers and traders. There is hope of common commercial code across countries. For example, the European Union is attempting to standardize law. Green marketing legislation. Environmental protection is a global concern. It extends beyond just pollution and hazardous waste. It focuses directly on environmentally friendly products. Germany has the most stringent laws. They regulate the management and recycling of packaging waste. Eco-label in Europe is for products that comply with this criteria. Foreign countries' antitrust laws. The US was the main enforcer in the 20th century. This reference is now used as a model for other countries. It focuses on issues to ensure fair commerce, anti-monopoly, price discrimination, supply restrictions, and full line forcing are highly penalized. U.S. laws apply in host countries. These laws are the ones that protect the country's political and economic interests. U.S. law holds true in foreign jurisdictions for the firm, its subsidiaries, and licensees of U.S. technology. Also, it doesn't allow to pay bribes, trading with the enemy, commercial ventures that harm the U.S., and unauthorized boycotts. The U.S. has the Foreign Corrupt Practices Act, or the FCPA, which says that it is illegal for companies to pay bribes to foreign officials, candidates, or political parties. It has stiff penalties for participating in bribery. Bribery is common business practice in many countries. Still, U.S. adheres strictly to the FCPA. Some argue this disadvantages U.S. companies in corrupt markets. U.S. antitrust laws that apply in foreign markets. It has two main purposes in international commerce. Protect American consumers by ensuring that they benefit from products and ideas produced by foreign and domestic competitors, and protect American export and investment opportunities against any privately imposed restrictions. In conclusion, defend the U.S. commerce against threatening foreign behavior of chief concern. Anti-boycott law. U.S. companies can participate in unauthorized boycotts abroad. They need to report any requests to cooperate in a boycott if they want to do it. The Arab League boycott of Israel has three levels. A primary boycott bans direct trade between Arab states and Israel. A secondary boycott bars Arab government from doing business with companies that do business with Israel, and a tertiary boycott bans Arab governments from doing business with companies that do business with companies doing business with Israel. This creates a challenging situation for U.S. companies. They are blacklisted by the Arab League if they trade with Israel, and if they do not trade with Israel, they are punished by the U.S. for participating in the boycott. Extraterritoriality of U.S. laws causes anxiety for foreign heads of states. U.S. laws can interfere with economic and political goals. Multinational corporations are held liable for activities that violate human rights, like doing business with oppressive regimes. These lawsuits are brought to U.S. courts by foreign countries. If the U.S. wants more firms to become multinational, it needs to make more provisions for resolution of conflict. When the intent of any kind of overseas activity is to restrain trade, there is no question about the appropriateness of applying U.S. laws. There is a question, however, when the intent is to conclude a reasonable business transaction. If the U.S. government encourages U.S. firms to become multinational, then the government needs to make provisions for the resolution of differences when conflict arises between U.S. law and the host government laws. U.S. policy on exports. Businesses can export without a formal license. Exports may need a license in certain situations. For example, commodities and U.S. technical data, re-exports to other foreign destinations, U.S. origin parts used to build foreign products. These licenses are controlled by the U.S. Bureau of Industry and Security. Over the last decade, the exports from U.S. have increased drastically. The Export Administration Regulations was published to speed up the process of granting export licenses by removing a large number of items from specific export license controls and concentrating licensing on a specific list of items, most of which pertain to national security, nuclear proliferation, terrorism, or chemical and biological weapons. Export restrictions. The sale of products cannot affect U.S. national security. Applies to American firms, their foreign subsidiaries, and foreign licensees of U.S. technology. Responsibility extends to the final destination of the product. Restrictions on weapons of mass destruction post 9/11. U.S. controls exports for a host of reasons: to protect and promote human rights, to enforce foreign policy, and to address any national shortages. Determining export requirements. The exporter is responsible for making the determination. If an item can be exported, he or she must choose the appropriate license. There are two types of licenses: the general license, which is not subject to EAR control, and the validated license, obtained only through a formal application, authorizes exportation with specific limitations. Acquiring export licenses. There are 4 electronic services that facilitate paperwork and expedite the process. These are ELAINE. It enables exporters that have authorization to submit license applications via the Internet. Stella. It's an automated voice response system for tracking applications. ERIC. It is a supplementary service to ELAINE. And SNAP. It is an alternative to paper license submissions. It enables an exporter to submit documents via the Internet.